All right, let's jump right into this explainer. If you're looking to build a high-yield study blueprint for the subjects of international law, you are exactly in the right place. Whether you're prepping for a final exam or you just want a crystal-clear framework of how the global legal system actually operates, we've got you covered. We're going to take the core doctrines and landmark cases and organize them exactly how you need to understand them to succeed.
So, who actually has rights and duties on the global stage? That is the fundamental issue you've got to tackle in any exam or essay on this topic. Historically, people thought international law was strictly the law of nations, meaning literally only sovereign states mattered. But the modern legal order has gone through a pretty radical transformation.
Here is our roadmap for building a high-scoring essay. We'll start by defining legal personality, contrast three competing theories, break down the categories of subjects, examine state supremacy, and finish off with some landmark case law.
Okay, part 1, defining legal personality. If this comes up on your exam, you absolutely have to start with a clear definition. Think of international legal personality as basically a VIP pass to the global legal system. To even be considered a subject of international law, an entity must possess this personality. It means they have the recognized legal capacity to perform very specific legal acts on the global stage.
Now, you'll want to memorize these 4 attributes because graders are literally scanning your essays for them. A really great trick is to remember claims, treaties, immunities, and liabilities. Basically, if you have personality, you generally have the capacity to bring claims before international tribunals, enter into legally binding treaties, enjoy immunities from the jurisdiction of national courts, and be held directly liable for violating international obligations.
Moving right along to part 2, the 3 competing theories.
Contrasting these foundational theories is a foolproof way to score extra points on an essay. First, you've got the realist theory, championed by Oppenheim, which argues that states alone are subjects, individuals are mere objects, treated almost like property. On the extreme opposite end, you have Kelson's fictional theory. He argued individuals alone are subjects, and the state is just a legal fiction representing a group. Today, though, we rely on the modern theory. This view holds that states are the primary subjects, but international organizations and individuals can also possess a specialized, qualified personality.
Which brings us to part 3, the actual categories of subjects. Under that modern view, we can break the players down into 4 distinct buckets. First up, sovereign states. They are the original subjects with absolute legal capacity. Then you have international organizations like the UN or the WTO, which have a functional capacity to fulfill their specific institutional duties. Third are non-state entities like recognized insurgent groups. They get a temporary, highly limited personality specifically for the laws of war. And finally, individuals. This is fascinating because you aren't just an object anymore. Individuals now have international duties, meaning you can be held liable at the International Criminal Court for egregious crimes. And you have international rights, meaning you can actually sue your own government under human rights treaties. That is a massive shift in human history.
Let's dive into part 4, the supremacy of states.
For exam purposes, you absolutely have to cite the 1933 Montevideo Convention. It's the gold standard for proving statehood. Under Article 1, an entity isn't a state unless it has a stable, permanent population, a defined territory with clear geographic boundaries, an effective government capable of maintaining internal order, and the capacity to enter into relations with other states. A quick tip here, that capacity element is usually the hardest to prove on a factual question since it really tests external sovereignty.
Now here's a distinction that will really elevate your essay: plenary versus functional capacity. States possess inherent plenary capacity, whereas organizations only have derivative functional capacity. Well, what does that mean? Well, plenary capacity means that just by existing as a state, you inherently possess all international rights and duties. It's absolute. International organizations, on the other hand, are limited strictly to the powers that states explicitly gave them in their founding charters.
So why exactly do states reign supreme? When you combine that plenary absolute power with territorial sovereignty, you have the definitive argument. States are the supreme architects of international law because individuals and organizations cannot create global laws. They can only be governed by the rules states actually consent to. Plus, only states possess the physical territory and the coercive machinery, like massive militaries and police forces, to actually enforce international legal obligations on the ground.
And that leads us to our final and arguably most high-yield section, landmark case laws. A quick tip for exams. Always frame the case with its core issue, using the IRAC method. Take the 1948 reparations case. Following the tragic assassination of UN mediator Count Folke Bernadotte in Jerusalem, the core issue was this: does the UN Charter implicitly give the UN the legal capacity to bring a financial claim against a sovereign government?
This holding from the International Court of Justice is a perfect quote to just drop right into your essay. They ruled that organizations do have legal personality, but, and this is key, it is limited and derived entirely from their functions. The court decided that to perform its global peace missions, the UN inherently needs the capacity to protect its agents. This officially opened up international legal personality beyond just states, permanently changing the landscape.
Next up is the Nottebohm case, which really tests the limits of an individual standing. The facts here are actually pretty wild. Friedrich Nottebohm, a German national, lived and worked in Guatemala for over 30 years. Right as World War II broke out in 1939, he traveled to Liechtenstein, bought a naturalized citizenship passport to avoid being treated as an enemy alien, and went right back to Guatemala. But Guatemala confiscated his assets anyway. So Liechtenstein stepped in and tried to sue Guatemala at the ICJ to demand his property back.
And from this, the court established the highly testable genuine link standard. They ruled in favor of Guatemala because Nottebohm had no genuine social attachment or shared life in Liechtenstein. His citizenship was literally just a passport of convenience. This matters immensely because it proves that an individual cannot access international justice on their own. They are entirely dependent on a state's diplomatic protection, which has to be backed by a real, factual bond.
Finally, we have the Mavromatis Palestine concessions case. This one is brilliant because it perfectly maps out how a private grievance transforms into a formal international dispute. Mavromatis was a Greek engineer whose valid economic concessions were just ignored by Great Britain after World War I. As a private individual, he had absolutely zero standing to sue the British Empire globally. But then, recognizing his plight, the government of Greece stepped in, adopted his claim, and challenged Great Britain directly.
This is a fantastic reality to highlight in your conclusion. Once Greece adopted his claim, the whole nature of the case magically transformed from a private commercial dispute into a state-to-state international conflict. The state is asserting its own right to ensure international law is respected, and that proves individuals ultimately still lack direct, unassisted standing on the global stage. All right, let's wrap this all up in our conclusion. Here is your ultimate takeaway to tie everything together. The system has definitely modernized to include diverse secondary actors, but the sovereign state indisputably remains the primary anchor of global law. The reparations case proves organizations have functional personality. Modern treaties give individuals specific rights, but the state alone possesses absolute territorial sovereignty and plenary legal authority. Non-state actors rely entirely on the structural framework established by those sovereign states. As you prep for your exam, I want to leave you with this final, provocative thought to chew on. The system is evolving rapidly, with international organizations and individuals gaining more functional and direct rights every single year. Will the sovereign state always remain the supreme architect of international law? Thanks for joining me for this explainer. Good luck studying and stay curious.